I'm happy to take some more of your thoughts on it via the WhatsApp line 0786 10 11 12. It's gone 3 minutes now after 7. Capitec Bank has won a major tax case against the revenue services. The Constitutional Court has ruled in its favor, granting it the right to claim a VAT deduction of almost 72 million rand. The matter dates back to November of 2017, and after a lengthy legal battle that saw the case being dragged from the tax court to the Supreme Court of Appeal, and finally now the Constitutional Court having settled questions around the Value Added Tax Act and how VAT deductions on loan cover payments are treated. Michelle Phillips is now on the line with us, a tax attorney at Tax Consulting South Africa, on the line to explain essentially for us, Michelle, what is at the heart of this VAT dispute. Good morning.
Yes, good morning. Thanks for having me. Yes, so as you said, it's gone through a number of our courts. So Capitec advertised free insurance cover for loans they were offering to their clients. And then they tried to claim tax deductions against the cost of providing this free insurance. SARS disagreed and issued an additional assessment against them. This is when Capitec approached the tax court, which held in their favor, but the Supreme Court of Appeal was on SARS' side. That's why we are now sitting with the Constitutional Court ruling.
And when then does VAT returns become, let's call it, lawful or eligible? Since in this instance, Capitec designed a very clever product, to offset what they would have charged for insurance, and they did not quite do so, and for them to not be shortchanged, essentially wanting the taxman to pay for it, which is uncertain how SARS viewed this issue.
Yes, so the general rule is a VAT vendor cannot claim a tax deduction against VAT-exempt services. Financial services such as bank loans are such VAT-exempt services, but the banking fees are not VAT-exempt. So Capitec tried to claim the tax deductions against the free insurance they were offering. Usually a deduction against the insurance contracts in question would only be allowed where the insurance was charged for. But it does get a bit technical here. Capitec relied on SARS Interpretation Note 70, which says that a tax deduction is allowed if this cost is incurred for marketing or promotional efforts. So Capitec's claim is that because the free insurance was part of its marketing and promotional efforts to stay competitive in the market, they then qualified for the input tax deduction against the insurance cost incurred.
And would it, by virtue of a verdict in its favor, does it seem that the Constitutional Court bought that argument?
Yes, it does. So SARS obviously disagreed, and then the Supreme Court of Appeal held in favor of SARS. So the exempt supply we're talking about is the loans that the Capitec offered. But say a vendor offers shoppers a free item as a marketing ploy. The free item has a nil value, although it is taxable supply. The VAT on that supply would also be nil. But it is important for items such as this to be classified as a taxable supply, so the vendor can deduct the VAT against the VAT incurred when they acquired such goods. The vendor can only deduct in such cases where the goods are supplied in the course of making taxable supplies. It follows now that Capitec's supply of the loan cover was not disqualified from being what's called a taxable supply, merely because it's supplied free of charge. And this is where the Supreme Court of Appeal got it wrong.
But if you are designing a product, with the view of staying attractive in the market, in the promotion and the essential hooking of potential clients for your loans, that's the exposure that you're meant to be taking, because there's no taxes or VAT being paid for it to be claimed at the later stage, of course, from the state. And so it would seem, look, I mean, I haven't read the very the minutiae or the small details of the verdict, and again, I'm not very much proficient in tax law or anything like that, but to me it seems here that the state is essentially footing the bill here for a very clever product of Capitec.
So not necessarily the state, but the VAT that's been charged through. So yes, that's a good point. But the interesting part for us is that the Constitutional Court has actually exercised its jurisdiction over tax court matters. So there has been a trend where the Supreme Court of Appeal does seem to generally find in favor of SARS. So it will be interesting to see whether the Constitutional Court will be taking on more appeal cases in the future.
All right, very precedent-setting matters at play here, and we'll look at it very, very closely. Thank you very much, Michelle Phillips. Michelle is an attorney at Tax Consulting SA, talking to us about a Capitec verdict now in regards to an ongoing saga since 2017.